Hello, everyone. Today is the first session of the Bishkek Arbitration Day, which will be devoted to the dispute resolution in the time of pandemic. And during our session, we will talk mostly, we will try to elaborate the question, can the arbitration be the answer? I would like to greet everyone who joined us. I know that we have a lot of participants from around the world. Thank you for joining us. My name is Natalia Alenkina. I'm Associate Professor of the American University of Central Asia. I'm as well advocate in a private legal firm in Kyrgyzstan and the arbitrator in International Court of Arbitrator under the Chamber of Commerce in Kyrgyzstan. It's a great honor and pleasure for me to moderate this session. Today we have a really star panelist, and I want to say special thanks to organizers for inviting so distinguished panelists. And let me first start by introducing our speakers. I have a pleasure to introduce Mr. Ilya Putilin, who is a co-founder of Putilin Sippel. He has been recently appointed as court member of the Tashkent International Arbitration Center and holds a position of adjunct professor at the American University of Central Asia. My congratulations, dear colleague. Ilya worked as a deputy head of legal service at the Asian International Arbitration Center and secretary general of the Asian domain name Dispute Resolution Center. As a part of this institution, Mr. Putilin co-led a team of counsel and supervised more than 3,000 adjudication, arbitration, mediation, and domain name dispute cases. He represented and advised clients in more than 50 cases before the most eminent tribunals all around the world, foreign and domestic courts of all levels, including the Russian Federation Supreme Court and international trade tribunals. Welcome, dear Ilya. Our second speaker, who I'm pleased to introduce, is Olena Perepelynska. She is a partner and the head of the CIS arbitration practice at INTEGRITES international legal firm. She serves as the president of the Ukrainian Arbitration Association, member of ICC International Court of Arbitration in Paris, member of TIAC Court of Arbitration, Russian Arbitration Association board member, and member of Global Steering Committee of ERA-Pledge. Thank you very much for joining us from Ukraine. And let me move to our next eminent speaker, Mr. Alexander Milner. He is a barrister of Fontaine Court Chamber in London. He is one of the very few Russian-speaking advocates at the London Bar, and consequently has a busy CIS practice both as counsel and arbitrator. This summer, he is due to appear remotely in two substantial LCIA arbitration, one a 500 million fraud claim arising of the collapse of Russian bank, and second one, 200 million fraud claim brought by Russian allies. We are happy to see you, Alexander, and we hope that we have our fourth panelist. His name is Hafez Virjee. Maybe he joined us just a little later. He is the president of Delos Dispute Resolution, an international arbitration institution. He also serves as an independent arbitrator. Hafez previously spent over 10 years acting as a counsel at large international law firm in London, Paris, and Dubai. Hafez is qualified in England and Wales and in France, and regularly writes and speaks on international arbitration. We hope he joins us just a little later. Dear colleague, I'm very happy to greet all of you, at least virtually. I would inform our participants that we decided not to prepare the formal conventional presentation. We just tried to do the live free discussion on the main topic of our session. And I hope that at the end of our session, we will have maybe 5 or 2 minutes for a QR session. So you may ask your question in chat, and I will announce it and we'll discuss it at the end of our panel. Okay, and I would like to inform you the main topic which we will discuss during our session. We will talk mostly about the pandemic influence, the dispute resolution. All of us witnessing that the impact is rather significant, and as a result of lockdown implemented to combat the spread of infection, court system of many countries have been paralyzed. No cases registered, no hearing held. The situation in Central Asia is not the exception of the rule. For instance, in Kyrgyzstan, during the March and April, there were no already hearing during these months. The court system is slow to adapt and react. The only viable option remains dispute resolution mechanism, alternative to litigation. And I would offer to go to the first question, which we planned for this session. It may sound rather provocative, but we want to discuss the role of arbitration for the CIS-related disputes. Is the arbitration a default or the preferred option for CIS-related disputes? And using my role of moderator of this session, I would like to start this discussion and briefly present the situation in Kyrgyzstan. I would like to briefly present the practice of the International Court of Arbitration under the Chamber of Commerce of Kyrgyz Republic. It is the oldest institution in Kyrgyzstan. It was established more than 16 years ago. And now the list of arbitrators of ICA covers more than 400 arbitrators. Most part of them belongs to the foreign jurisdiction. The total number of cases considered by the ICA is 1,022. Of course, most of them are internal cases, but more than 60 cases considered where the one or two parties belong to the foreign jurisdiction. As a rule, it is a CIS country like a Russian Federation, like Kazakhstan, Uzbekistan, Tajikistan, and Ukraine. But not only, we have some cases with participants far abroad, like Germany, China, of course, Great Britain, America. According to statistics, the plethora of cases considered by the ICA are devoted to the loan agreement, loan dispute, credit disputes. They are followed by the disputes on lease contract, purchase contract, service, and work contract. And in order to our participants more fully understand or perceive the situation with arbitration in Kyrgyzstan, I would also highlight just three elements which differ us from other jurisdiction. First of all, the status of arbitration here in Kyrgyzstan has a constitutional status. For us, it's very important. In a time of change, it gives a sense of stability for the arbitration center here in Kyrgyzstan. The second one, we have any procedure for setting aside of arbitration award. It means the total final status of arbitration award, which cannot be appealed or set aside neither procedurally nor substantively. And the third issue, arbitration in Kyrgyzstan have a rather wide competence. For instance, we have no such limitation, any limitation for instance, for corporative disputes or for disputes with state authorities, because in the special law on the public procurement or the public-private partnership, we have a direct link to the arbitration. And you may know, it's a rather hot topic of our current day. The deputies, the legislators currently initiated the new law, the draft law, which offer to transfer tax cases to the arbitration. Okay, in order not to abuse the power of moderator, I will stop at this here, and I would like to give the floor to other speakers who will observe the situation with arbitration in other arbitration institutions. And first of all, I would like to offer Alexander to share with us the last statistic of LCIA. And after that, I will be happy to hear other speakers of our panel. Please, Alexander.
Thank you. Good morning, everyone, or good afternoon for those closer to Bishkek. The situation, so far as England is concerned, is easy to analyse because the LCIA, which is our main arbitral institution, has published some statistics recently for cases started in 2018. There were 317 cases and nearly 10% of the parties involved came from CIS countries, so quite a high proportion, mostly from Russia, Ukraine, and Kazakhstan. But in addition to that, there was also a significant number from Cyprus and from the Caribbean, 5, 6, 7% from Cyprus, and the same from Caribbean. And a lot of those will also involve Russian parties, because obviously, as we know, it's very common for a CIS entity to do business through Cypriot holding companies. So in total, it's a very significant part of the LCIA's work. I should say, though, for comparison, that the figures in the English commercial courts, our state court, are not very different from that. For the same period, something like 3 or 4% of the parties in English court proceedings came from Kazakhstan, and a slightly lower number from Russia and Ukraine, in total about 9%. So I would say England as a venue remains very popular for CIS parties, at roughly equally split between arbitration and litigation.
Thank you, Alexander. I would give the floor Olena Perepelynska, who will continue the presentation.
Thank you, Natalia, and hello, everyone. It's nice to see at least online and to talk about the developments in the region. So, with regard to the default choice for CIS parties, I think it's still the first choice is the choice of local institutions, whatever the party comes from. So, for example, for Ukrainian parties, the first choice would be our main arbitration institution called AUCA, or International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry, and it has in average 300 or 400 international cases per year, so it's quite considerable caseload. And then the second choice would be some local institutions in the region, probably depending on the counterparties. So for intra-CIS disputes, it would be most probably one of the CIS institutions. And then there are a variety of international or regional institutions. And I think they've top 3 are the main arbitration centers in Europe. So ICC in Paris, SCC in Stockholm, and LCIA in London. So each year the statistic could probably differ, but in general it's more or less the same. We also have some cases in Vienna, and we have, returning to London, we have quite many cases in GAFTA and FOSFA, so as there are a lot of export of grain and oil from the region. So this is more or less the overview. And just to mention whether it's default option or not, in Ukraine, historically, when Ukraine got independence, Ukrainian government promoted using arbitration for any international contracts. We had a governmental decree with a kind of template of international commercial contracts, which literally said to have an arbitration clause. That's it. Thank you.
Thank you very much. Very interesting. Ilya, can you add something to the discussion?
Yeah, I would say the interest in arbitration in Central Asia is growing, of course. Just name a few developments: the establishment of Tashkent International Arbitration Center, the establishment of new Bishkek Arbitration Center for mining, conferences, a number of conferences held in Central Asia, Uzbekistan, Kyrgyzstan, Kazakhstan. So this shows that if it were not the preferred option, it would be the preferred or default option in the years to come. As far as the venues for arbitration is concerned, I would say in Central Asia, the preference, of course, historically is Sweden and Stockholm, but there are also some unconventional venues, so to say, like Switzerland. Most of the contracts with Chinese parties, no matter what the value is, have the Swiss Chambers clause, and this is surprising. So the parties, even for small transactions, say under 500,000 euros, are eager to explore arbitration as the means of dispute resolution. And this is fascinating. I would say in Central Asia, in most international contracts, the arbitration clause would be the default mechanism or default clause to be included.
Thank you, Ilya. Dear colleague, I'm very grateful for such an excellent start, and please let me move on to the next question. Let's try to discuss the benefits of the arbitration for CIS countries. Why do CIS parties opt for the arbitration?
I will start, if you don't mind. Yeah. So I think one of the major advantages of international arbitration is enforceability of arbitral awards. I think it's even more important for the CIS region because historically the CIS states did not have so many bilateral or multilateral treaties on mutual assistance in civil or commercial matters. That means that they do not have a treaty basis for enforcement of state court judgments. And it was always a problem. And still, I think the number of those bilateral or multilateral treaties is not very high for any of the CIS states. And that is why the tool of available in an international arbitration, namely the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, is a very unique and very useful tool when we have a dispute under international commercial contract. And for now, I have just checked the UNCITRAL website. So there are 163 parties to New York Convention. So this is amazing. I think this is one of the most successful international treaties today. And this makes the international arbitration so successful because it grants the same regime of enforcement of arbitral awards almost all over the world. Thank you.
Thanks a lot, Lena. Alexander?
Yes, so another often cited benefit of arbitration is confidentiality. Arbitration proceedings are always conducted in private. They're usually also confidential, meaning that the parties and the arbitrators are not allowed to refer to the arbitration materials outside the arbitration. That can be very attractive if your contract is about a sensitive subject, or if you're a state and your state officials are likely to have to give evidence and don't want to give evidence in public and that sort of thing. The extent to which confidentiality applies does differ between different rules and jurisdictions. So it is something that you need to check before agreeing to a particular type of arbitration or type of a particular seat. But generally, there will be some degree of confidentiality imposed on the process. I think it's also worth noting that in practice, confidentiality is not always absolute. So, for example, there can be court proceedings arising out of the arbitration which inevitably puts information in the public domain. So it shouldn't be assumed that nothing will leak into the public domain, but that is certainly less likely to happen with arbitration than court proceedings. And if I could just make a link to the title of our session, which is about the impact of the pandemic, there are, I think, risks to confidentiality inherent in the current trend for remote arbitrations, because, for example, how do you ensure that unauthorized people don't watch the proceedings or record the proceedings and distribute recordings and so on? It does become more complicated to ensure confidentiality, and I'm not sure that those questions have been fully answered yet, but perhaps we can discuss that more later on.
May I add something about confidentiality and Central Asia nexus? An interesting thing is that in Uzbekistan, court rulings, as far as the enforcement is concerned, are anonymized. So it prevents information about the parties leaking out. Natalia, correct me if I'm wrong, in Kyrgyzstan, those rulings are not even published.
Right.
I could add that in Ukraine, all court judgments are publicly available and only the names of individuals are anonymized. So you could find a lot of information if the parties are legal entities. So you could find any judgment about setting aside of enforcement of arbitral award in public domain.
Dear colleague, dear participants, I would like to introduce our fourth participant. This is Hafez Virjee, who joined us just a little late. Hafez, we are just discussing the benefits of the arbitration for the CIS country, and we have just discussed the confidentiality and enforceability. If you can add something, please.
Yes, certainly. So first of all, I'm delighted to join the Bishkek Arbitration Days and apologize for this delay, which is due to personal circumstances. To the broader question of our panel, I think it's a timely topic, and more specifically to the question of arbitration for CIS parties, I will add to what my colleagues have been saying, a comment about neutrality. It's all very well to be talking about a dispute resolution forum, but when you're talking about parties with different nationalities, from different backgrounds, neutrality is essential. And neutrality in arbitration means two things. There's the neutrality of the forum, meaning neither side needs to go to the other side's courts, and there's a neutrality of the arbitrators, which traditionally is understood to mean a neutral nationality as compared to that of the parties. Now, there are different ways in which we can expand a discussion on this topic. Maybe for now, I'll only add that I think Ilya may be talking about flexibility or certain other considerations, and so not to overstep too much on what he will be saying. If you look at neutrality, part of what it achieves is the ability as well to be equidistant from the parties culturally. And more specifically in our context, it means that you can, while being neutral, be culturally sensitive to both sides because of the flexibility of the process. Which means that then when you look at why arbitration, CIS parties can have the confidence that they're buying into a process which understands them while being acceptable to their international counterparts.
Thank you, Hafez. Ilya, as Hafez referred to you in part of flexibility, maybe you add something on this point.
Thank you, Hafez. Natalia. Another obvious benefit that comes to my mind when it comes to arbitration is flexibility. And the question arises, flexibility to what extent, and flexibility compared to what mode of dispute resolution? In general, arbitration offers greater flexibility as compared to national litigation, right? The degree of flexibility would depend, of course, on the mode of arbitration, be it ad hoc or institutional, on the applicable rules, on the applicable laws. For example, if we take Kyrgyzstan into consideration, the degree of flexibility is rather wide and rather high, because the scope of arbitrability is large. The requirements as far as the arbitration procedure is concerned, the mandatory requirements are rather limited, but it may not be the case in other jurisdictions, right? So it is flexible, and the parties can tailor the procedure to their needs. More often than not, the CIS-related disputes that are referred to arbitration are construction disputes. And this is where the flexibility comes into play and truly shines. Because in national courts, when you have a construction dispute and you want to appoint an expert, usually the court would appoint an expert based on the suggestion of the parties. So you are losing this opportunity to present your case the way you wanted to. In arbitration, each party would have its own expert, so the chances are equal, and there is no third figure who would decide who would be the expert in arbitration. Another issue to consider is representation. Usually, there are no limits as to who can be a representative in arbitration, whereas the national court would require you to hire a local bar member, which may not be convenient for you, not to say may not be appropriate, because the local bar member may not be speaking your language. If we are talking about, say, China, Kyrgyzstan contracts or China, Uzbekistan contracts, this is not a problem in arbitration. You can be represented by anyone, not even a lawyer. So in general, to sum up, arbitration is flexible, and this is something the parties are considering when drafting their contracts, when adding their arbitration clause.
Thanks a lot, Ilya. I would ask a question. You know that arbitration is always associated with the high prices. And I'm interested is, does this benefits come with the price? Maybe some of our experts can add to this question. Elena?
So, you know, it would greatly depend, of course, of the institution chosen. And even within one institution, there are different set of rules with different, with potentially different fees applicable. Of course, when you have a choice of having experts or having some flexibility, this would add cost as well. If you have any additional services available to the users, that would definitely entail additional cost, but it does not mean in all these situations that it's something disadvantageous, because it's up to the users to decide whether they want to have this additional service or not. So, and that is why when we talk about flexibility and the financial issues, I think it's very good that the users could choose. They could choose the option depending on the financial status, possibilities, and that is why I think it's also sometimes it's expensive, that's true, but still there are many ways how to make it more cost efficient. Thank you.
I referred to confidentiality earlier. I think that the disadvantage of that is that I think publicity is good discipline for arbitrators. If you're making decisions in public, then you tend to take greater care to get them right and to give good reasons for them. And if arbitrators are relieved of the obligation to justify their decisions to the world at large, then lazy habits can creep in, and doubtful reasoning it can appear more commonly. Another thing that should be said about arbitration, generally it's possibly an advantage, is that there are very limited rights of appeal, and that means that disputes end more quickly and cost less money to get to a final result. But it does mean that mistakes made by arbitrators generally do not get corrected. So there is more risk in that sense in the one-stop process that arbitration entails.
Natalia, if I may add, just came to my mind that in terms of financial benefits, if we compare state litigation in the region and international arbitration, one important option is also to look for external funding. So there is a growing industry of third-party funders. They're normally not based in the region, but they could give funding for international arbitration cases. They would probably not fund any domestic litigation case, and that is why international arbitration gives this additional advantage of having the dispute resolved using someone else's money, rather than to go to the state court in the region where the potential respondent is located. And of course, again, further to just to mention additional services and financial issues related to them in arbitration, we could have we could record the hearing, we could have transcript, we could have various types of translation, either simultaneous or consecutive, and so all this is available. Of course, this is not for free, and this probably makes the proceedings more expensive, but again, this is the party's choice. Thank you.
If I may add something to that extent. First of all, yes, it comes with a price, answering your question. The other question is this price affordable, or is this price reasonable? And it would depend on the drafting of the arbitration agreement, which we discuss later, and which our panelists for second session would be discussing, because much would depend on how you agree in your contract. Whether you have 3 arbitrators, 1 arbitrator, whether you have institutional ad hoc arbitration, whether you have early dismissal, everything would influence the price. Adding to what Elena said, we have a number of third-party funders registered for the conference, and it means that they are interested in Central Asian market. But the question rather to them, not to us, whether they are interested to invest in small and middle-sized claims, because at the end of the day, most of the cases that receive third-party funding are large-scale disputes, and most of the parties who are disadvantaged by the price of arbitration are small and middle-sized entities. So if third-party funding is available in Central Asia to small and middle-sized enterprises, I would say, and this was my prediction, the number of cases from Central Asia would skyrocket.
I might add 2 thoughts here, if that's okay. One is, it's implicit in the discussion, but I think it's worthwhile making explicit. Namely, there's a part of the difference between domestic and international arbitration is a difference in terms of comparable dispute resolution opportunities. Domestic arbitration can be compared with litigation because it's all in the same frame, as you might say. And then you are definitely comparing time and cost. Whereas international arbitration, you don't really have that many alternatives that are binding, that are transnational, and allow you to achieve an enforceable outcome. And at this point, then I will add as a second comment, which something that I would have added earlier on in the conversation, which is part of what sets Delos Dispute Resolution apart is not only its emphasis on efficiency, but its proportionality in terms of costs in relation to the amount in dispute, to the point where even on small disputes, it remains affordable and appropriate as a solution.
Thank you, all of you. Really interesting issues you raised. But now we are smoothly move on to my next question. I would say that the question on arbitration agreement is one of the most fundamental question in the all arbitration procedure. And if you don't mind, I would like to ask our prominent speakers provide our participants very short and information about the forming the arbitration agreement, like ABC for arbitration agreement. If you may, maybe Ilya, could you please start?
Thank you, Natalia. So everyone understands that an arbitration is a creature of contract. So you must have a contract in place to be able to refer your dispute to arbitration. And the question here is what dispute, right? How to draft this arbitration contract properly to have the dispute you are having arbitrated. And it brings us to the first issue of arbitration clauses. An arbitration agreement is the scope of arbitration agreement, the scope of arbitration clause. The scope of the clause as such would depend on a plethora of factors. The first, of course, is drafting by the parties. The second is the law of the seat. The third would be the law applicable to the arbitration agreement. So how one would interpret or construe the arbitration agreement. As far as the first factor is concerned, the drafting, the rule of thumb would be to go with a standard clause offered by many institutions. Why is that? I reckon, and I wouldn't be lying, that each of us at least once encountered a clause that was overly complex, that was so poorly drafted that at the time the arbitration were to be commenced, you wouldn't really understand whether this dispute is covered, is caught by the arbitration agreement. So the rule of thumb would be to go with the broadest scope possible and to go with standard clauses recommended by arbitral institutions, because these clauses are history tested, they are stress tested, and they are usually up to date. Remember the ICC model clause that was amended after the Supreme Court of the Russian Federation judgment requiring the name of the arbitral institution to be mentioned in the arbitration clause. And that's the case for Kyrgyzstan, because unless the name of the arbitral institution is mentioned, the arbitration clause is invalid. So you have to mention it. So as far as the scope is concerned, be broad, because you never know what dispute you'll have down the line. And unless you're a very sophisticated party, or unless you are being advised by an outside counsel, or you have an experienced in-house counsel, just use a standard wording, because these would save you time and costs down the line.
Thanks a lot, Ilya. Maybe other speakers can add something to recommendation of Ilya.
Well, I agree with what Ilya said, but particularly keep it simple. And in fact, it is generally sufficient just to say that disputes will be referred to arbitration under the rules of a particular institution, without then going into detail about what the process involved. Because as soon as you start drafting detailed provisions about how the process will work, they will inevitably conflict with the rules of the institution. And then you get disputes as to which prevails and what was really intended. And if you've got multiple agreements, there'll be inconsistencies between the various arbitration clauses that have certain procedural consequences that you don't want. So I think, yes, use precedent and keep it simple. The only thing that you probably should give particular thought to is whether to appoint a sole arbitrator or a panel of three, unless it's a very high value dispute. There's a lot to be said, in my view anyway, for having a sole arbitrator. It's much cheaper, it's more efficient.
If I may add a couple of words about scope perspective first. So I think it's also important to double check the existing court practice in a potential jurisdiction of enforcement of arbitral award, because sometimes, so as already mentioned, this Russian court case led to the change, the tectonic change, of approach to arbitration clause in a particular jurisdiction. And effectively, ICC has different types of standard clauses for, so it has like one standard clause for the majority of jurisdiction, and then there was a clause for China, and I think the same clause is now applicable for, or recommendable for, Russian cases as well. And in Ukraine, the situation was quite similar in terms of there were quite silly court approach that you need to mention the arbitration institution in the arbitration clause, and that is why until the recent reform, there were several negative cases on enforcement, setting aside of arbitral awards or arbitration clauses. But after the reform, Ukrainian courts are obliged to interpret any defect of arbitration clause in favor of its validity, enforceability, and possibility of being performed. That is why we don't have this issue now. But in terms of scope, for instance, Ukrainian courts may not consider that interpretation of arbitration clause, if it's not mentioned expressly in the arbitration clause, is necessarily included into the scope. And there were a couple of strange cases considered by the Ukrainian courts where they came to the conclusion that if it's not mentioned expressly in the wording of arbitration clause, then it's not covered. And that is why you need to be really careful when you draft your arbitration clause. Sometimes you need to add some types of dispute depending on the jurisdiction where you're going to enforce your, most probably, your arbitral awards. In terms of number of arbitrators, we move later to that topic. We're still on the scope.
Please, because it was mentioned.
It was mentioned by Alexander, and it's a very interesting question. Again, a tricky one, because surely you have three important documents which could influence the number of arbitrators in your dispute. That is the arbitration agreement, applicable arbitration rules, and arbitration law of the seat. And they could have quite interesting interplay between themselves. So even if you have if you have one arbitrator in your agreement, then most probably you will have your dispute resolved by the sole arbitrator. However, if you mention three arbitrators, for instance, that does not necessarily mean that in the end of the day you will have three arbitrators in your panel, because, for instance, some arbitration rules, as ICC has introduced the rules that for fast-track proceeding, which is opt-in option, the court could change the number from 3 to 1. And this is considered like pre-agreed by the parties when they choose ICC rules, and they agree that it could be one arbitrator. Or, for instance, in England, as I know, even you have three arbitrators in the clause, and some arbitration rules of the institution seated in London, or for ad hoc arbitration, I think, if one party appoints, claimant appoints the arbitrator and gives notice to the other party that the other party should appoint his or her arbitrator, otherwise the arbitrator appointed by the claimant would act as a sole arbitrator. And as I understand, this could happen, and if you are not prepared for some such development, you could simply miss your deadline for appointing the arbitrator as respondent. You could end up with a sole arbitrator appointed by the claimant. And another situation, if you have not chosen the number of arbitrators in the arbitration clause, sometimes you have put two arbitrators. For instance, in maritime cases, In some institutions like FOSFOR, for instance, you could have two arbitrators, so the one appointed by the claimant, the second one appointed by the respondent, and if they do agree, they could resolve the dispute just by two arbitrators. If they do not agree, then they could have an umpire or a third arbitrator, or it could have different titles, but at the end of the day, you will have three arbitrators instead of two.
Could I just comment on that, just because I see there's a question, which is an interesting question, and one which touches on what Aliona was just talking about. I don't know if people can see it, but the question's been raised as to whether parties will now adapt their dispute resolution clauses to cater for changes of circumstances such as the pandemic, and if so, how? And I think that's one very good example of an area that people will now have to give more thought to. It's certainly something that's arisen in a case that I'm currently involved in, which is what happens if one or even more than one of the arbitrators becomes incapacitated. Most rules do cater for this, but in a rather cumbersome way that requires a second appointment process, and either by the parties or by the institution or even by the court. And that's not very practicable, particularly if you're 3 years into a long case and approaching a final hearing, and a replacement arbitrator simply doesn't have time to get up to speed. So I do think that parties will need to consider providing expressly that in the event that an arbitrator becomes incapacitated or can't participate for any reason, then the remaining arbitrators, whether it's two or one, should be able to decide the dispute on their own. Obviously, remote hearings are something that will have to be written in, I think, because, I mean, in general, in my experience anyway, arbitration has coped very well with the pandemic and the need to move to remote hearings. But I think many people will want the comfort of knowing that they are guaranteed a hearing, even if it can't be a physical hearing, or not. I mean, there may be parties that are so value the right to a physical hearing, they don't want a Zoom hearing. That's also understandable. But I think, again, that's something that parties will need to think about and agree, because certainly the types of arbitration that are going on now, whether they're good or bad, are a long way from what anyone would have contemplated at the time when they signed their arbitration agreement.
May I add 2 cents to the answer to the question? I think in the future, the arbitration clauses or any dispute resolution clauses would be more carefully drafted to address the change in circumstances, and which it reminds me of the sanctions war or the arbitration reform in Russia, because in the interim, we had to draft arbitration clauses that say, look, if this arbitral institution is approved, the dispute would be arbitrated by this arbitral institution. If it's not approved by the Ministry of Justice, then it should be referred to this arbitral institution. Same for sanctions war. So if this arbitral institution cannot administer a dispute because of the sanctions, then the dispute would go to another arbitral institution that can administer this dispute, notwithstanding the sanctions. And Natalia, you mentioned that ICSE under Kyrgyz Chamber of Commerce was not operating during the pandemic's time to a certain extent, not normal business or operation. So the arbitration agreement referring the dispute to ICSE in this particular case can be considered frustrated. So what the parties should do, they can have a separate submission agreement, change the arbitral institution or change the procedure for dispute resolution, but they can also include something anticipating certain events in the future in the arbitration clause itself, if one can predict something to happen, because the pandemic and the coronavirus crisis was unpredictable. So you cannot say, look, in the event there would be a pandemic, then this arbitration clause is no longer valid, or this arbitration clause shall be construed as follows. But if you are able to predict certain events, yes, I'm more than sure that the arbitration clauses would be more sophisticated in the coming years, trying to anticipate what may happen in the future, what may affect the arbitral procedure agreed.
Thank you very much, Ilya. We have a question from our participant. It's related to what you have said. Should the arbitration clause reflect to the changes according to the pandemic situation? But could you please just a little more elaborate the question on the language of the arbitration agreement? I think it's also very important.
Sure. Although it's not related to the question of our participant, another part or pillar of the arbitration clause that is often neglected is the language of arbitration. This is particularly relevant to bilingual or multilingual contracts, because at the end of the day, you'll have a dispute with your counterparty as far as the language of arbitration is concerned, and having explicit provision saying that the language of arbitration shall be English or shall be French or shall be Russian saves time and cost down the line.
Thank you. Alexander, may I ask you to share with us your opinion about such condition of arbitration clause as a seat of arbitration? Is it important or not? How do we manage this clause?
Yes, it is. So just on the point of terminology, every arbitration has a seat, which is a place, but it denotes not the physical place where the arbitration takes place, but the legal seat. So the place where the award is deemed to be made. And in practical terms, the significance of it is that it is the courts of the place of the seat which have supervisory jurisdiction over the arbitration. So the courts which can issue injunctions or secure evidence and grant other kinds of interim remedies that affect the arbitration. So the choice of seat is important because different national courts have very different attitudes to arbitration and different remedies that they are prepared to grant in relation to arbitration. It's also in the courts of the seat generally that the award will be challenged in the first instance by the losing party. So again, different national courts have different attitudes towards arbitration awards, and some are much more willing to uphold them than others. That is why the choice of a seat is important. It should ideally be somewhere where the courts support arbitration and can be relied on to act efficiently, to grant orders where they're needed, and also obviously impartially. And that is why it's no coincidence that the most common seats in arbitration are places like London, Paris, Switzerland, Stockholm, Singapore, Hong Kong, which traditionally have been known for having efficient and neutral judiciaries with a positive attitude in support of arbitration. And it's why, unfortunately, despite the heroic efforts that are going on in places like Uzbekistan, Kazakhstan, and other CIS countries, and there is a lot of great work there being done by people to set up arbitration institutions and draw up rules and so on. They are at a disadvantage because their national courts in those jurisdictions are not known for being either neutral or to have a particularly positive attitude towards arbitration in some cases. So the seat does need to be chosen with care. The seat is not necessarily the place where hearings take place. As I say, hearings can take place anywhere in the world, or as is happening at the moment, nowhere in the world, with all the participants sitting in different jurisdictions. So you don't necessarily need to reach any agreement on that, but the seat is important. I was going to go on to mention a recent case in the English Court of Appeal where, but Natalia, I don't know, maybe I should come back to that because it's on a slightly different topic.
Sorry, Alexander?
So I was going to go on to mention the recent case in the English Court of Appeal about the law governing the arbitration agreement and why that matters. But perhaps I should come back to that later if there's time.
Okay, thank you, Alexander. Hafez, maybe you can add something to our discussion about the drafting the arbitration agreement? Any other important points?
No, I'll be happy to. And I think the one aspect that perhaps hasn't been developed fully yet is the difference between ad hoc and institutional arbitration. But just before I come to that, there was this, on the discussion about seats, there's one notion I care for very much, which is the notion of safe seats. And, okay, which is the notion of safe seats. And I don't know if, to what extent people are familiar with this, but I would define a safe seat as one that does not materially increase the cost for parties to arbitrate, whether that be directly or indirectly from having additional requirements. And I think when you're thinking about writing your arbitration agreement, there's a temptation to seat the arbitration where you are located. But in the flow of our conversation, which of what benefits arbitration can bring and at what price those benefits come, thinking about the seat and going to Alex's point, bearing in mind that the seat of arbitration doesn't mean that that's where people are meeting or holding a hearing is critical. Then more specifically about the distinction between ad hoc and institutional arbitration. Other than in maritime arbitration, arbitration is typically conducted under the auspices of an institution. And this institution provides rules and administers a dispute. In contrast, if you don't have an institution, parties must determine their own rules of procedure, thereby creating an ad hoc framework, which is why the name. Now, why would you choose one over the other? The arguments in favor of institutional arbitration indirectly point to the challenges of conducting an ad hoc arbitration. An institution provides predictability. For example, regarding the commencement date of the arbitration. It also reduces the scope for issues around the designation and remuneration of the tribunal. And then an institution exercises a control function. For example, regarding the fees of the tribunal, you avoid unsavory situations where a tribunal might be saying, can you up my remuneration? It allows you to address issues of challenges to members of the tribunal. So for example, if the arbitrators whom you thought were neutral or independent or impartial finally come across to you as being biased, then you've got a forum in which to raise that without having to go to court, because that would be the alternative. And the control function can typically extend to the quality of the awards, meaning institutions frequently exercise some form of scrutiny of awards. Now, if you were to balance out the picture a bit, ad hoc arbitration allows you to completely tailor your procedure to your needs. And it's a bit like if you decided that for this webinar, you were going to build your own web browser and build your own live streaming procedure. In other words, it can work, but you want to exercise that with care.
Elena?
If I may just add a comment with regard to the last two topics, institutional versus ad hoc and seat versus venue. It's also important if you choose institution to look whether the institutional rules allow to choose the seat of arbitration, because for many institutions the rule is to have the seat in the jurisdiction where the situation is physically located and registered, while other institutions do allow to choose the seat in any jurisdiction of the world. And actually, if you have, say, ICC, you could choose the seat in any jurisdiction, including Kyrgyzstan, for instance, and you could have Kyrgyzstan seat for ICC arbitration. While I assume the local institution in Kyrgyzstan, ICAC, does not allow to move outside Kyrgyzstan to have their arbitration in any other jurisdiction. So it's important aspect to check. Thank you.
And if I could, sorry, I'll just add one point. and this goes to the overall conversation, which is when you have a dispute, you want to be focusing your resources on resolving that dispute. And so really the importance of the conversation we're having right now is you don't want to have issues with your arbitration clauses that create additional disputes for the resolution of really what's at the heart of your problems.
May I add a quick note on seat and venue and linguistics in arbitration. In many languages, there is no distinction between seat and venue. And if you're drafting a multi-language contract or bilingual contract, it's always advisable to have the place of arbitration and place of hearing instead. Because, say, in Vietnamese, when I tried to explain the concept of seat and venue, I was surprised that they cannot grasp the idea at all, because there is no distinction between seat and venue. Same for Russian language. Seat and venue can be used interchangeably. So when you're drafting a contract, it's advisable to have place of arbitration if you want to refer to a seat, and place of a hearing if you want to specify a venue.
Dear colleague, thanks a lot. I'm really fascinated by the level of our discussion, but unfortunately time is going and we move on at the end of our session. Just in order to summarize our discussion, I would like to repeat the question which I put at the beginning of our discussion. Can arbitration be the answer? And if you don't mind, I would ask all of you during a minute or short, just share your opinion about the look forward conclusion about the future of the dispute resolution, please.
May I start answering your question? So the most common answer you get from a lawyer, it depends. So arbitration surely is an answer. Whether it is the answer depends on a number of factors: your contract, your disputes, whatever crisis there will be in the future, because you never know whether the arbitration would be capable of tackling the crisis. As far as the pandemic is concerned, yes, arbitration is a viable option. Many arbitral institutions continued operating during the lockdowns, continued accepting the cases, continued registering the cases, continued appointments. So there was no interruption as far as the arbitral procedure is concerned. In any event, arbitration after coronavirus crisis would never be the same. And I reckon the coronavirus crisis would affect the way arbitrations are conducted going forward. So the parties may be referring more to online modes of arbitration, be it document-based only or be it virtual hearings. So arbitration would change. Whether it would answer the complexities of tomorrow, you will never know.
Thanks a lot, Ilya. Do anybody want to add something?
Yes, thank you. I agree with what Ilya said. I think that arbitration was already well set up for these sorts of circumstances, and we were already used to hearing witness evidence remotely, to exchanging documents electronically and using electronic hearing bundles and so on. So the only thing that is new is the scale on which these sorts of techniques and technologies are being used. And generally it is adapted very well, and no doubt there are going to be some teething problems, but it is quite a robust and flexible system, and I'm sure it will be continue to be used. If I could just add one word on the question that's been asked as to whether in a corrupt environment arbitration is more prone to corruption than court proceedings or not. My very quick answer to that, it's a very interesting question which could probably fill a whole session, but arbitration is less prone to corruption, I think, for the simple reason that if you have a 3-person tribunal, you're only likely to be able to corrupt one of them at most. At least 2 of them should be appointed by the other side or by neutral authority and be from a very different culture. And it is it's going to be more difficult to corrupt than even 2 members of the tribunal, which you need in order to win a case. There are no doubt horror stories that everyone can recite about where things have not gone as they should have done. But generally, I think arbitration is more neutral, as Hafez was explaining earlier, than court proceedings would be in a state where the courts are known to have problems with partiality.
Alexander, did you have any experience with such cases, especially in developed nations?
I have not, to my knowledge, been involved in a case where a tribunal has been corrupted. I mean, of course, it's in the nature of corruption that one never knows. But I have had a case, it's a different form of corruption, but it's something that arbitrators in particular need to be aware of. Not whether the tribunal is bribed as such, but where the proceedings themselves are used as a means of money laundering or some other illegality. So quite often you see it, well, not quite often, but sometimes you see a dispute which mysteriously settles, and the tribunal is asked to make an order endorsing a settlement agreement for the payment of large sums of money under an award. And you do wonder whether there was ever any real dispute in the first place, or whether it's somehow a collusive process that shouldn't be happening. So that I have seen, but I haven't, as I say, to my knowledge, encountered bribery in arbitration. But clearly there are cases where it has happened.
Thanks a lot. Alena?
Yeah, I could follow the discussion of whether arbitration could be announced. I totally agree with previous speakers, and it really could be, and it has proven during this crisis that it could adapt. It's flexible enough to adapt to rapidly changing circumstances. Although arbitration was prepared, better prepared than the court system, it still has adapted to unprecedented lockdown in many countries. So many institutions amended their rules to make their proceedings paperless or close to it. They allowed to file documents in electronic form. So we had, and now we even we have even more online hearings. So, and we probably will have new normal after this COVID-19, and this is something discussed very broadly. It's interesting that the COVID situation also gave a new life, so to say, to the Green Pledge, initiated some time ago by one of well-known international arbitrators. So the idea behind this is to make arbitration more eco-friendly and to reduce the impact of arbitration to our environment. So this is again about traveling, about using of paper, etc., etc. So, and the changes we see indeed makes arbitration more green. It's interesting.
Thanks a lot. Hafez?
It's difficult to come after everybody when I agree with what everyone has said. I'd say maybe 2 thoughts. One that goes in this same trend as what everybody said, which is arbitration has done very well. It's definitely a dispute resolution mechanism for the 21st century. It's proved it over the past few months. It's adapted rapidly on the point of there were, for example, certain forms of inefficiencies that have adapted very fast, such as the practice that you still see in some places of filing a case with paper. That doesn't work when everybody's in lockdown. And that raises issues of legal certainty when you want to know what the commencement date for your arbitration is and when was your statute of limitations interrupted. So arbitration has done very well, and it's embraced technology very rapidly and very effectively. I'd say maybe, since I'm coming at the end of this conversation, a word of caution perhaps for arbitration. As arbitration becomes even more prevalent in commercial disputes and prevalent not just in terms of the number of disputes, but in terms of which disputes are coming to arbitration versus going to court, there is a risk that commercial law doesn't keep adapting and evolving in the same way as when cases also go through the court system, and whether a stated precedent system applies or an implicit one applies, commercial law evolves as a result. So I think there is a question for us arbitration practitioners about not necessarily the confidentiality of arbitration, but about how we show our work product. How does commercial law keep evolving on the basis of all the work and all the thinking we're doing, and on the basis of the new issues that are arising that would, had they gone through the court system, given rise to the commercial law adapting to the new problems we encounter in business. That's the word of caution I put out there, but I'm happy to for my co-panelists to say otherwise.
Dear colleague, thanks a lot. I see that we are on time. It means that we manage our session very good. Unfortunately, we have no time for the question, but I tried to include the questions during the presentation of our speakers. So I hope that all questions which were asked of our participants were covered by during the discussion. From my side, I would say thankful for all of you for the really fascinating, insightful discussion, for your interesting answers, for the questions. Thanks a lot. I would like to say many thanks to the organizers for the good organization of this session. I would say that our session come to the conclusion. Thank you very much, all of you.
Thank you so much for moderating, and thank you for joining Bishkek Arbitration Days.
Thank you.
Yeah.
Thank you very much.
Congratulations.